Hi, I'm Stephen Kennedy of Kennedy Law. Today I'd like to talk to you about the tort of breach of fiduciary duty and why that's a matter that should be of importance to all business owners. The tort of breach of fiduciary duty was defined in Johnson versus Brewer by the Texas Supreme Court in 2002. The Texas Supreme Court defined it as, quote, generally speaking, it applies to any person who occupies a position of peculiar confidence towards another. It refers to integrity and fidelity. It contemplates fair dealing and good faith rather than legal obligation as the basis for the transaction, end quote. With that definition, the Texas Supreme Court is saying that it is going to look at each case on a case-by-case basis to determine whether or not there is a peculiar relationship or a special relationship between the two individuals involved to determine whether a fiduciary duty exists. So, for example, if you own a business and you have what you call a business partner who you trust to run certain operations of the company, perhaps balance the books or run the financials, that could very well fit within this special duty of trust, whereby one employee trusts the other at the company to do their job correctly. And if they don't, a breach of fiduciary could arise. Rather than talk about this concept in the abstract, I'd like to give you a specific example. So I recently represented a business executive who had gone out on a brief 2-week leave for a surgical procedure. During that time period, he entrusted 2 of his employees to take care of certain customers, handle their needs, etc. When he came back, the employees announced that they weren't happy with the way things were being run, and they had one excuse after another as to why they didn't think that the company was being run correctly. And they wanted to end the corporation. The executive was stunned. He didn't know what to think. So he reluctantly agreed that yes, they would dissolve the corporation. And then after the meeting was over, he thought about what had gone on and did a little bit of research. He contacted building security about what the activities of these 2 employees were while he was gone. He looked at their company email. He discovered that while he was gone, they had wheeled out of the company boxes of documents that belonged to his customers, in which the customer had entrusted to the company. He found through their email that they had specifically tried to solicit those customers to go with them to a new competing venture, all while he was out having a medical procedure. Well, obviously, this created a completely different scenario. The company executive decided that he needed counsel, and he employed Kennedy Law to try to determine exactly what he could do. In response to what the employees did, the executive retained Kennedy Law. And it was my view that rather than go charging in down to the courthouse to get a temporary restraining order or a preliminary injunction, the best thing to do was try to mediate the dispute and resolve it in a peaceful fashion. Through mediation, we demonstrated what we had found. We showed them the emails where they used company resources to solicit clients. We demonstrated that they had taken firm materials, including computers, using the surveillance cameras of the building. We demonstrated that a special duty of trust existed between the executive and the employees. It turns out in the end that the employees returned the company property, and all of the customers that they had tried to take that belonged to the original executive stayed with the company. So, in a nutshell, a breach of fiduciary duty is something whereby there's a special relationship, a special trust, and that special trust is broken. In this particular case, the business owner was very lucky because you're not always going to have a situation where you've got video surveillance or company email being used to accomplish a breach of fiduciary duty. That's why I recommend to my clients that you have a strong employment agreement or a strong partnership agreement that specifically says exactly what the obligations of each individual will be. I also recommend highly a covenant not to compete and a non-solicitation agreement so that if an employee decides to set up their own competing operation, they're not going to solicit company customers or even other employees at that company for a specific time period. This will help protect your company over time. I'm Stephen Kennedy, and this is our video blog for today, July 5th, 2017. I hope it was of use to you. Have a good day.